Hello, my name is Josh Blackman, and it's my honor to welcome you to the final four round of the 2022 Harlan Institute Ashbrook Virtual Supreme Court competition. This year, we're doing the case of students for fair admissions versus University of North Carolina. We have a distinguished bench today. Presiding will be Judge Eric Murphy from the Sixth Circuit, Judge Alice Batchelder, also from the Sixth Circuit, and Judge Ken Lee from the Ninth Circuit. For petitioners, we have Campbell Collins and Gabrielle Evans from Texas, and Colin Young and Aaron Strauss from New Hampshire. Without further ado, Chief Justice Murphy, whenever you're ready.
Thank you. Happy to be here. Happy to be here with Judge Batchelder and Judge Lee, and we will call our first case, Students for Fair Admission versus University of North Carolina. The petitioners can begin when they're ready.
May it please the court. My name is Campbell Collins, and along with my co-counsel, Gabrielle Evans, I represent the petitioners, Students for Fair Admission.
We today ask this court to overrule Grutter v. Bollinger. The University of North Carolina employs an affirmative action program that benefits certain races to the detriment of other races. This program is unconstitutional for three reasons. First, UNC's policy fails strict scrutiny. Second, Grutter v. Bollinger should be overturned. And third, there is no historical precedent for such an affirmative action policy.
First, strict scrutiny is the appropriate standard to apply today. The justification of the educational benefits of diversity for a race-based affirmative action policy is not compelling, and UNC's policy is not sufficiently tailored. For these reasons, Grutter v. Bollinger should be overturned.
This court held in Adirond v. Pena that all racial classifications imposed by whatever federal, state, or local governmental actor must be analyzed by a reviewing court under strict scrutiny. In other words, such classifications are constitutional only if they are narrowly tailored measures that further compelling governmental interests. So today we have to look at if there's a compelling government interest and if this law is, or this policy is being narrowly tailored to achieve that interest. The educational benefits of diversity, as brought up in Grutter and by UNC, is not a compelling state interest. When we look at the tradition of using compelling state interests in Supreme Court cases, we see three types of things that are normally used. These are national security, safety from violence, and the functioning of government. The only other compelling interest we've used is the educational benefits of diversity in Grutter. And that's not a compelling state interest. In fact, we found the best interest of a child and providing minority role models to alleviate the effects of societal discrimination to be not compelling interests.
What do you would concede though, wouldn't you, that Grutter held to the contrary, that it is a compelling interest?
Yes, Your Honor, and we're asking for Grutter to be overruled.
So what about I guess Grutter's been the law now for over 20 years. What about the reliance interests? When we think about stare decisis, we think about various factors, and one of those factors is reliance on the ruling. Haven't college administrators in implementing their admissions policies come to rely on Grutter and developing those policies?
Well, Your Honor, potential reliance interests aren't enough reason not to overturn Grutter in this case for a couple of reasons. First, because as this court held in Brown, if implementing a non-discriminatory policy would be difficult for schools, that's not enough reason to stop discriminating. Furthermore, there are really no legitimate reliance interests because no one has a legitimate interest on dividing students based on their race and affording educational opportunities based on their race. And even if there are reliance interests that would be disrupted, respondents' proposed remedy is even more disruptive. They're asking this court today to reconsider Bakke, as they state on page 3 of their brief, which is even longer standing precedent.
Now, even UNC doesn't find the educational benefits of diversity to be a sufficiently compelling interest. And we see this because they're unwilling to get rid of legacy admissions to increase diversity without using racial classification. They're more interested, as they themselves have said, in the donations that come from legacy families than truly achieving diversity in their schools.
You had earlier mentioned that national security could be a compelling interest. That I don't know specifically about UNC, but a lot of state schools have ROTC programs, and their ROTC programs are a pipeline for the officer ranks in the military. And some military generals have said that they need a diverse officer rank to complement the enlisted military folks. So why isn't it a compelling interest for the military to have a diverse officer rank through ROTC programs at state universities?
Well, Your Honor, at the very least, ROTC programs and military academies would require a separate analysis. But the very small percentage of students who go to the majority of public and private schools and then end up in the military, that small minority of students is not enough justification for discrimination that affects all students, even students at colleges who send very few or no students to the military. So that comes back to the tailoring requirement. A broad-based affirmative action policy that affects students of all races at all schools is not sufficiently narrowly tailored to be specifically designed to address diversity in the military. And that's not even the government interest that UNC is claiming to address, because they're claiming to address just educational diversity and its benefits more broadly. So not even specifically directed at the military.
So are you taking the position that there isn't a way to narrowly tailor an attempt to achieve this kind of diversity?
Well, Your Honor, we are saying that the educational benefits of diversity don't rise to the level of a compelling state interest. The educational benefits of diversity are a good goal. They're an important goal, but they can be achieved in other ways, and they're not a compelling government interest. But with this law, we would also say it is also not narrowly tailored. This court held in Fisher 1 that strict scrutiny imposes on the university the ultimate burden of demonstrating, before turning to racial classifications, that available workable race-neutral alternatives do not suffice. They haven't done that.
Fisher really emphasizes that the university receives no deference on this point, that just because they claim that they don't have alternatives doesn't necessarily mean that that's true. And UNC hasn't sufficiently demonstrated that race-neutral policies could not achieve the same ends.
Can I ask you, maybe switching gears a little bit about your historical analysis? It seems to me that the Freedoms Bureau laws really undercut the position. Don't they at least evince that the founders thought that promotion of the African Americans after the war was perfectly okay, that it was consistent with the 14th Amendment to help the freed slaves? So why isn't that historical evidence a suggestion that promoting diversity today or promoting disadvantaged folks today is okay?
Well, Your Honor, the Freedmen's Bureau Act was dealing with your legal status as a former slave, not your racial status as a Black person. All freedmen were Black people, but not all Black people were freedmen. This did have a racially disproportionate impact, but it worked in a race-neutral way. It is actually a great example of what we should be doing now, which is finding ways to help disadvantaged communities and communities that have been directly harmed by the government, but we have to do it in a race-neutral way.
Furthermore, the idea that we can use these affirmative action policies as some form of racial remediation is simply not true. We have the prior case law that has gotten rid of that as a justification for affirmative action policies, which is why universities have turned to this broader goal of educational diversity. But because educational diversity is so far separated from all the other compelling state interests that the court has found to be sufficient justification for discrimination in the past, Grutter just doesn't stand up to constitutional scrutiny because it's creating this new category when it's not necessary to do so.
Now, not only does Grutter's definition of a compelling interest, not only is it flawed, but it also doesn't meet the factors laid out in Dobbs for good precedent.
Dobbs laid out 5 factors that we can look at when determining whether precedent should be held to stare decisis or whether it's time to overturn that precedent. Grutter fails these factors. It's egregiously wrong, it's weak and inconsistent, it's unworkable in practice, it's disruptive, and it has generated no legitimate concrete reliance interest.
Was it really unworkable in practice? I mean, Gruder's been around for over 20 years and schools have certainly been doing this.
Well, yes, Your Honor, Gruder has been around for over 20 years and schools have still been using affirmative action policies, but the affirmative action policies that they've been using don't line up with what Gruder told them to do. For example, Gruder has this concept of a critical mass, that you can use affirmative action policies to gain a critical mass of students, but UNC doesn't use that idea. And in fact, an expert testified that they weren't sure they'd know what a critical mass is. So we can see that Gruder is unworkable because universities aren't using it even when they do have affirmative action programs.
We pray that this court will reverse the decision by the lower court, overrule Gruder, and grant the petitioner's appeal. Thank you.
Thank you, counsel. We'll hear from other respondents next. Counsel for the respondents. Okay, you may proceed when you're ready.
Mr. Chief Justice, and may it please the court. Petitioner accuses that respondents are seeking to uproot an even more basic precedent than Grutter in Bakke. But in reality, respondents' request to overrule Bakke and change the rationale for defending affirmative action policies to an implementation of intermediate scrutiny or a historical standard does not upset precedent because of the fact that, as Justice Murphy said, the heart of stare decisis is about reliance interests. The reality is Grutter holds many reliance interests, such as the millions of people, minorities, every year who rely on Grutter to gain college admissions. On the contrary, the rationale of Bakke does not hold any such reliance interests. After all, Bakke's overruling and the expansion of affirmative action policies as requested by the respondent would only protect the reliance interests of all involved.
However, even if this court is not inclined to overrule the strict scrutiny standard, respondent prevails. It is clear that the many benefits of diversity in higher education, especially military interests, as Justice Lee said, which are well attested to in our brief and in the briefs of several amici, constitute a compelling state interest, and the record below definitely shows that respondents' admissions policies are indeed narrowly tailored. As Justice John Paul Stevens wrote in his dissent in Adirondack v. Pina, we cannot disregard the difference between a no trespassing sign and a welcome mat. Specifically, respondent today asked this court to reconsider the application of strict scrutiny to laws which benefit minorities. The petitioner today has a high burden to prove with regards to the historical record. They must prove that race may never be used in any manner by any university like respondent for any purpose. They fail to do so. On the contrary, the historical record clearly shows that the framers of the 14th Amendment did not believe in equal protection of the law as an abstract ideal, but as a practical reality, namely the reintegration of minority groups that were previously excluded from society.
Can we start with just the plain text? I understand you have a intentionalist argument about what the framers had in mind, but they implemented that purpose with a text that is very difficult to see how it can distinguish between races in a way, whether the government is acting to benefit one race or exclude another. It says quite categorically, no state shall deny to any person the equal protection of the laws. So I'm curious how we can read that text to allow some racial divide and not other racial divide, depending on whether we think it is good or bad.
Well, Your Honor, we believe many of the framers participated in the Freedmen's Bureau and that those beliefs carried over. For example, in the Freedmen's Bureau, it may have helped a variety of people, but it's universally understood that the Freedmen's Bureau was meant to help Black people. They used a holistic system that factored in race to determine who needed help in the same way UNC does with affirmative action. Trumbull, who was a large part of the Freedmen's Bureau and a framer of the 14th Amendment, stated that relief is for those who need it, not those who already have it.
Furthermore, Your Honor, this court has never understood the 14th Amendment to mean that governments can make no distinctions between persons. Rather, this court has a lengthy jurisprudence with different tiers of scrutiny that deal with different categories. And we're only asking that the category for discriminating in favor of minorities should be updated to be in line with what the original purpose of heightened scrutiny was. And therefore that discrimination that benefits minorities should be treated differently than discrimination that hurts minorities because of the fact that minorities lack democratic political power.
Well, you know, we have a related case involving Harvard University, and the allegations in that case is that the school has discriminated against Asian Americans in favor of white applicants. So in that case, what level of scrutiny should we apply here? Because the allegation in that case is that it is a racial minority that's being discriminated against under the school's policy.
Your Honor, if it is demonstrated that the group being discriminated against is a minority group and the group that's benefiting is a majority group, then we would agree that strict scrutiny would be the appropriate standard.
What happens?
Although I'm not entirely familiar with that case.
What happens? You know, the population statistics change over time, and I think there's some studies that suggest that whites in this country will eventually become a plurality. Do you think that the Constitution's meaning should change with the changing racial demographics of our country?
Your Honor, this court's jurisprudence has always given special favor to discrete and insular minorities, not only in this context, but in others, by being more likely to apply heightened scrutiny to those cases. We're only asking that strict scrutiny be limited to cases where indeed the group in question is discrete and insular minority. And we don't believe that lengthy population changes over long periods of time will lead to instability in the law.
Your Honor, furthermore, in regards to the treatment of Asian Americans in the admissions process, we believe that they should be, that due to the historical discrimination against Black people, that Asian Americans should be treated in a conglomeration with white Americans as a total majority, which again goes to the point that a discrete and insular minority, like Black people in the United States, should have intermediate scrutiny applied as opposed to strict scrutiny.
You would concede, though, that there has been historical discrimination against Asian Americans. I mean, dating back to World War II with internment camps, and even before that, I recognize the fact that they weren't slaves, but you would certainly have to concede that there has been historical discrimination against Asian Americans.
Yes, Your Honor. And indeed, that's why our standard doesn't look to the past, but rather to the present. So the relevant factor is not whether or not Asians have been hurt in the past, it's whether or not Asians currently hold political power. We think that the correct way to go about this is to consider the whole group of people which are being harmed, which in this case is alleged to be white and Asian Americans, which as a group do not constitute a discrete and insular minority by any definition.
Well, can I ask you a quick question about, I thought your historical evidence on the original meaning of the 14th Amendment and the Freedmen's Bureau and the protections designed for slaves was quite helpful to your position, with the caveat, though, that it was the federal government that was passing these laws. And the 14th Amendment only applies to the state governments. And so do you think that this is good evidence of what the framers had in mind with respect to attempting to restrict the states simply because the 14th Amendment would not have applied to the Freedmen's Bureau legislation because they were acts of the federal government? So how would you kind of address that? How does that affect the historical analysis?
Your Honor, we're trying to look at what framers would have meant by the phrase equal protection of the laws. And we have no reason to believe that the same phrase, equal protection of the laws, would have meant different things in a state law context and a federal law context. Because the framers in the past used that phrase in programs that specifically helped minorities as opposed to being completely race neutral, we have good reason to believe that they would have supported similar programs when the same verbiage was used in federal laws or in state laws, rather.
Well, what do you make of the counter argument that all of these, your friends on the other side suggest that all of these laws were also race neutral in the sense that they didn't expressly single out somebody because of their race, They applied because of past conduct, their past slavery, and therefore they were, in that respect, race neutral, which could suggest that the framers intended for a colorblind constitution, and that you should today look at socioeconomic factors as the basis for determining who needs help.
Your Honor, to this point, we understand that while the Freedmen's Bureau was meant as a remedial measure, we are not saying that affirmative action is the same as the Freedmen's Bureau, but rather that the Freedmen's Bureau demonstrates the founding fathers' intent this demonstrates the founding fathers' belief that that our Constitution is not colorblind, given that they used the Freedmen's Bureau in order to counteract existing prejudice in society and to reintegrate Black people in society at the time. And we believe that this shows precedent for how we can use the same thing in affirmative action today.
It's a huge leap from using race to remedy people who were enslaved to now using a much more amorphous diversity rationale to consider race, isn't it?
Yes, Your Honor. Well, we believe that the amount of discrimination may have changed due to the multiple statistics we referenced in our brief. We believe there's still demonstrable discrimination in society today that needs to be resolved, and that should be counteracted in order to ensure the important government interest of diversity in education.
Wait, so you're saying it's the school's policy is justified by need for diversity or to remedy discrimination?
Your Honor,
we're saying that the government interest in question is indeed diversity. We believe that remediation is another potential, that remediation in the time of slavery would have also served as an important and compelling government interest. But we're saying that in present, diversity is sufficient to qualify as an important government interest under the standard which this court should adopt.
How should we deal with Justice O'Connor's statement back, 20 somewhat odd years ago that we probably won't need affirmative action, 2 decades from now? Does the diversity rationale mean that affirmative action will last forever?
In the contrary, Your Honor, we are confident that at some point in the future, and we believe this is the sentiment that Justice O'Connor was employing, the diversity rationale will no longer be a rationale because it won't be necessary to use external racial factors in order to create equality of the races. But currently, we believe that the outstanding effects of discrimination have hindered certain races in a way that this kind of intervention is necessary to create diversity in college admissions.
Is there an objective statistic from which we can identify when it will no longer be necessary? Is it like what is the goal we're trying to achieve? It's somewhat amorphous idea that someday it may be unnecessary, but today it is necessary. Like, what factors will show that it's no longer necessary?
Your Honor, we believe that once a certain critical mass within colleges is reached, within graduation rates, within jobs, within our military force of officers is achieved, that will be a point at which measurable statistics can be used in those percentages in order to determine that racial discrimination is no longer significant enough to warrant affirmative action.
Has anybody come up with any kind of an objective standard for figuring out what is a critical mass?
Your Honor, we believe under our intermediate scrutiny framework, it might look something like this. So this is a model. For example, the reason why we would say diversity is an important government interest right now is because the difference in the amount of diversity between the amount that would occur if we didn't use affirmative action and the amount that would exist if we did use affirmative action is really significant enough to constitute a government interest that's important. But in the future, if different races of students like Blacks and Latinos were to achieve at the same level so that even without affirmative action, we'd be reaching similar levels of diversity, the difference between the two would no longer be as significant, which would make it less likely to be an important government interest under our standard.
I'd like to think you actually answered my question, but I'm not sure you did. How are you going to figure out the level that you just talked about? Is there some way we can look at that and be able to determine when we've gotten there?
Yes, Your Honor. We believe there are multiple metrics which we can use. One of the most common ones that we currently use is when the representation in higher education is equivalent to the population percentage of the overarching United States. Once
is
that
this a
threshold is
quota?
reached,
Is this a
Your Honor?
quota?
No, Your Honor. We're just saying that that would be one example of a standard. So if the populations of different races in universities were to approach the populations in the general population, that would suggest that the interest of diversity is already being pursued without the aid of extra programs.
Thanks. Well, with your remaining time, I wonder if we could transition from Judge Lee's question about Justice O'Connor's 25-year suggestion. How do you think that suggestion should affect the stare decisis factors when the opinion itself has a baked in expiration date? Doesn't that suggest that Grutter should have less stare decisis effect? And you can answer and go over a little bit, and then we'll switch.
Yes, Your Honor. On the contrary, we don't believe that it was actually a deadline of any sort that Justice O'Connor was mentioning. I don't think Justice O'Connor was intending to have the decision expire. Rather, she was expressing a sentiment which we all share, which is that we hope it will not be necessary. But we find 20 years later that it is still, in fact, necessary, contrary to Justice O'Connor's predictions.
Okay, thank you, counsel. We'll hear rebuttal. You may proceed when you're ready.
May it please the court.
We'd like to address 3 points brought up by the respondents. First, strict scrutiny is the correct standard based on this court's precedent. Second, the standard doesn't change based on who is being discriminated against. And third, societal discrimination is not an acceptable, compelling state interest.
First, strict scrutiny applies here. We can see that from precedent stretching back to Adirond, Fisher, and Croissant. It's important to apply strict scrutiny because anytime the government discriminates on the basis of race should be looked at with extreme suspicion.
Second, the standard doesn't change based on who's being discriminated against.
As Justice Thomas said in his concurrence, in my mind, government-sponsored racial discrimination based on benign prejudice is just as noxious as discrimination inspired by malicious prejudice. In each instance, it is racial discrimination, plain and simple.
What do you do with the famous footnote from Caroline Products that suggests heightened scrutiny should only apply to discrete and insular minorities? I think that your friends on the other side were suggesting that that is the basis for treating historically discriminated minorities differently from other races.
Well, Your Honor, we find it unfair to call 14% of the population discrete and insular. And we have to look at the vast majority of students who are being discriminated against, and it gets quite complicated.
So we know from prior case law that when we're looking at discrimination in higher education, there's been some contention about what exactly that means and how schools do that. But throughout all this precedent, the consistent factor since Adirond has been that we apply strict scrutiny to this, because any time that a school is discriminating against a student based on that student's race goes directly against the court's holding in Brown, which found that there's no reason for schools to be using race in affording educational opportunities. And even with race-based affirmative action programs that are intended for good reasons, it's still the case that race-based discrimination is not acceptable.
Now, respondents use this example of a welcome mat and a trespassing sign. Welcome mats, they say, are acceptable, while trespass signs are not. But in today's case, it's a little bit more like a welcome mat where it says welcome to certain races, but it says no trespassing to other races. It's not a perfectly benign system with no harm to other students and other races.
We can see from the record that an African-American applicant in the 4th highest academic decile has a higher chance of admission than an Asian-American applicant in the top academic decile.
Is,
So
is the university context a little bit different from other contexts? Because university, one of the reasons why we go to school in colleges is to be exposed to different ideas that you may not have been exposed back at home. So diversity is really important in the university as part of the educational mission of schools. So isn't that a very important goal for schools, to expose students to people from different backgrounds, different races, different views?
Well, Your Honor, it's true that true diversity of thought and experience and outlook is essential to university higher education, but UNC bears the burden to demonstrate that they somehow need race in order to achieve that kind of diversity, which they haven't done.
Furthermore, their concept of diversity is a little bit both nebulous and seemingly stereotyping, because there's so many types of diversity. There's diversity of political opinion. There is diversity of skin color, diversity of gender. And UNC is obsessed with this idea of diversity of skin color. And they're relying based on what you click on a little checkbox to try to get an understanding of the viewpoint that you're bringing, which then falls into stereotyping these students based on their race. And finally, remedying societal discrimination isn't a compelling state interest. In Wygant, this court held that societal discrimination without more is too amorphous a basis for imposing a racially classified remedy. And Justice Scalia, in his concurrence in Croissant, gave us an example of what type of discrimination may have a remedy. Giving a previously rejected Black applicant the job that by reason of discrimination had been awarded to a white applicant, even if this means terminating the latter's employment.
So respondents' justification must rely solely on this educational benefits argument, and that's simply not compelling enough to justify categorizing students based on their race and giving them opportunities based on that race.
Thank you.
Okay, thank you, counsel. The case is submitted.
If I could come back on camera and say to everyone, congratulations. That was a very, very impressive round. I have to remind myself that you're all 16, 17, 18 years old, and you're not, third-year law students. That was extremely impressive. I will just give some feedback myself, and I'll let the judges sort of opine. One thing that I loved what you did was that you made this responsive to the questions. You would always say, Justice Lee said this, and Justice Murphy said this, and my friend to this side said this, and you went back and forth. That is not easy, right? This means that you're not only preparing yourself quite well, but you're on your feet and you're paying attention to the question the judges are asking. And then when it's your turn to speak, you're building upon those questions to sort of jab your other side, which is very good, because maybe they disagree, but argument's a conversation between the judges and the lawyers, right? And if you're making this a one-way conversation, it's not very effective. But a two-way conversation there. You're all respectful. You answer the questions yes or no, then pivoted immediately. You had a full command of both history and precedent, Wygant this and Trumbull that, right? You're pulling in things that are simply not known by people your age. And I'm not blind to the idea that you have two Asian American advocates arguing against an Asian American judge about how this discriminates against Asian Americans. I'm not blind to that fact, and you played the role, right? Whether you agree with it or not, you are, I think, putting on your advocacy hats and taking a position for your client that is very strong. And I don't mean this lightly, but we often get very cynical and jaded in society, and we sort of see things that aren't so great in our society. But when I see the four of you, I'm like, okay, things aren't that bad, right? If this is what we have to look forward to in the bench and bar, not like what happened at Stanford, if you see this kind of stuff, it makes me, sorry, that's TMI, but makes me relieved. So maybe Justice Murphy and the others could maybe get some feedback as well to our students. But
Sure. Yeah. No, I thought it was fantastic. I can start with just the briefs. You guys all spent a ton of time on the briefs. They were quite thorough. I was very impressed by them. And then in terms of today, the advocacy, I completely agree with the notion that it's a conversation. I personally, for instance, like asking hypothetical questions because it helps me determine your legal rule. So for the respondents, that's why I asked the question, for instance, what happens with changing demographics of the country? And I thought you answered the question. And the same with respect to petitioners and the history and doesn't the Freedmen's Bureau really kind of count against you? So I thought you did a great job. I thought you made good eye contact to the extent you can make eye contact on Zoom, which for about 1.5 years, I struggled with Zoom arguments during COVID. But and I thought that the pace, when I was an advocate, my pace was always way too fast. And I realized now that it actually is very detrimental because I can only ingest 20% of what you say if you're speaking really fast. But now I thought your pace was great. I could understand both sides. So that was usually my biggest pet peeve for myself was I think it came from nerves, and I assume you're both very nervous. So or all of you are very nervous. So I thought you did a great job there. You definitely had a commanding sense of the material, which I thought was fantastic. Being able to talk about esoteric Supreme Court cases apart from Brown, which everybody knows Brown, but all the other cases that have come along since then. So I think you all did a very a great job, and you should be proud of yourselves.
I don't have very much to add to that. I would say that if you were nervous, you sure hit it well.
Yeah.
All four of you did extremely well at that. The respondents, when I said that I wasn't sure you'd answered my question, you handled that very well. I was impressed. As Judge Murphy said, I was impressed by your briefs. It's really hard to imagine that you guys are only 16 or 17-year-old students here. You did as well as an awful lot of law school moot courts that I have judged. And it's really encouraging to see not only how well you did, but that you're interested enough to be putting this kind of time and energy into it. You are all four very, very well spoken, which is not necessarily true of all of your contemporaries, I'm sure.
Or practicing lawyers.
Yeah, no kidding. So I'm just really encouraged by what I saw here this afternoon, and I congratulate all four of you on a job extremely well done.
I'll echo those comments. Again, excellent job by all four of you. With respect to nerves, I didn't sense any nervousness on anyone, but if you felt it, it's okay. I remember a talk given by David Boies, who you guys are too young to know who he is, but famed trial lawyer. And he said every time he goes up to the lectern, he said he has butterflies in his stomach, even though he's this famed trial lawyer, because he said, if I didn't have butterflies in my stomach, it means that I don't care anymore. And he obviously cares about the cases. So it's good to feel. It's okay to feel a little bit nervous. Not that it showed here. Again, the briefs were excellent. I told my law clerks this morning that there's no way I could have written something like that as a high school student. Maybe not even in college. So I mean, great briefs, great presentation on the part of everyone. Again, I can't sign up a good advocate is I have no idea what you guys personally believe, but yeah, you guys did an excellent job in presenting each side's case.
Good. And let me just make one more comment. I've seen these students progress now over 4 rounds. I've judged all the prior rounds. The first round I judged with some of my students, then I judge also with some of my colleagues in the law faculty, and they're getting better. Each round they're improving. The arguments are getting sharper. They're making fewer mistakes. And I noticed mistakes made in the last round you didn't make in this one. There are certain things that you were going to say and then didn't say. I noticed and exactly where it happened, and you avoid the pitfall. So to Judges Murphy, Batchelder, and Lee, you got these students sort of at their peak, right? I don't say peak, that's the wrong word. They've not reached the apex yet, but they have climbed up the cliff in the mountains substantially in just a few weeks. So I'm very proud. I always like to give the students a chance to ask questions of us. We have 3 sitting federal appellate judges here. What do you want to ask us? I'm happy to answer, but they're probably more interesting to talk to.
Sorry, can you hear me? Alright, I don't really have very many questions regarding the argument, but I just wanted to ask if either of you three had any advice for like an aspiring future lawyer, what to do in college, law school, etc.
Well, I can start. For me, you know, I've always been an appellate lawyer. It depends on what type of lawyer you want to be. I'm naturally an introvert, so what David Boies did standing up in trial would have been terrifying to me. What appellate lawyers do is we just kind of like write all day. So you have to figure out what you like to do. But I think no matter what type of lawyer you want to be, I think you want to keep working on your writing. So this was a great project for you to write an actual brief. I think I find writing very difficult, and it just comes with time and practice and editing. So having the way to become a better writer is just to practice writing. So I would encourage you to keep up your writing if that's what you want to do. Other things. So when I was in law school, I really didn't. I think this might be ahead. I guess when I was in law school, I really had no idea. I was just like by the grace of God, I guess the way and it worked out okay. But I think developing internal contacts is important. So at law schools or even in undergrads, because they could just be thinking about, and when I'm an undergrad and I want to go to a particular law school, I'm going to have recommenders. And you want to have recommenders who know you really well. And you want recommenders who might know the law school faculty or and from the law school faculty who might know judges if you end up clerking. So that's something I didn't really think about. And it just kind of, and if it had happened after, like looking back, you know, I had a really great mentor and a professor, but that just developed because I was interested in his work. So I would encourage you to make contacts as you continue through your process. So writing and kind of making contacts with folks who can serve as recommenders.
I would definitely second Judge Murphy's saying to pay serious attention to your writing skills. You've done very well with these briefs. I should start with the caveat that I used to be an English teacher. So I saw some places where if I had you right in front of me, I would, you know, have you do it over. But you're so young. You have so much time ahead of you to really learn how to write extremely well. One way to do that is something that you may or may not have much exposure to, but one way to do that is by reading the classics. In an awful lot of high schools and even colleges today, you're not encouraged to read the things which are really beautifully written from times past. Just, I guess they're no longer viewed as being particularly important or germane, but they are, and they can teach you how to write really well. Learn the rules of grammar. I mean, really learn them so that you can really use them. And you will then be head and shoulders above a lot of your competition. So that's my first thing. And my second thing maybe is going to sound a little strange, but if you're really thinking that you want to go to law school, now's the time, and especially once you get into college, to begin thinking about why you want to go to law school. There are really lots and lots of very mediocre lawyers out there. And partly that's because they really went to law school because they didn't have anything else to do, or they didn't know particularly why they wanted to do this, but it seemed like a good idea at the time. So spend some time thinking about, why do you want to do this? What kind of law? And I know this is a very preliminary stage for you, but start thinking about what kind of things in the law intrigue you. What kind of law would you want to be practicing? And sort of let that help you as you decide what you want to do, where you want to do it, and what specific kind of law you would think you'd like to end up with. In law school, obviously, you can't be specializing like that. You have to, well, but you can in law school take the courses that are really going to actually help you once you become a lawyer. There are an awful lot of courses that you can take that really aren't. So I would encourage you not to do that.
On a similar note, I have a lot of classmates who no longer practice law because shortly after graduating from law school, they realized they really didn't like the law. So right now, I know you guys obviously are very interested in the law, but you guys are very young. So, make sure you are interested in it. It's not just, gosh, I don't want to take organic chemistry to become a pre-med major, so I'll just go to law school. Surprisingly, there are a good number of people who do that, and they end up, spending 3 years in law school, and tuition is very, very expensive these days. So that's a very expensive degree. So make sure you, yes, as Judge Batchelder said, make sure you really do want to pursue law. Also want to echo the importance of writing. It's not even just in appellate courts. When I was in private practice, a good chunk of my practice wasn't before trial courts, district courts, and a lot of writing involved, and a lot of the motions judges don't hear, especially district courts, they're so busy, they don't hear argument for a lot of the motions because they just don't have the time. So they'll decide purely on the briefs. And sometimes it's on even dispositive motions. Sometimes they won't hold oral argument on a summary judgment motion. They're going to decide that. And I can tell you, even with appellate argument, at least in the Ninth Circuit, probably about 25% of the cases, maybe even more, we don't hear oral argument. We decided solely on the briefs. So your briefs may be the only chance to persuade a judge. So writing is very important. And I always say, good brief should in many ways be kind of, and then the writing style, like a New York Times article or Wall Street Journal article, very easy to understand, clear, structured, and you're able to explain, difficult concepts in a very easy to understand way.
All right. What other
So
questions
much
do you
there.
have? Anyone from Gabriella?
We're both wanting to know, Judge Batchelder, what your favorite books are that you'd recommend, because we really love reading and we get excited about books.
Question.
Well, I wish I'd known you were going to come up with that one. There's some almost maybe more areas. I've always been a real fan of Shakespeare. And it's fun to read as well as to be able to see in performance. I'm probably dating myself when I say that I did enjoy Jane Austen. A much more modern writer, but classical one, is Wendell Berry, who writes absolutely beautifully. And that's, well, in my judgment, well worth pursuing. I'd have to think about it some more. I've been reading an awful lot of law for the past 40 years. Haven't been spending as much time reading the things that I want to. So I would think back a little bit, but there's some starters at least.
I'll tell you what, I could, if you email me later, Judge, if you think about it, I can pass on to the girls and to Aaron and Colin, and we could make a reading list. I'm sure they're going to read whatever book you say. So we'll put it out there.
Also, I have always been someone who really enjoyed reading poetry, and not that it necessarily gives you the kind of writing background, but at the same time, it gives you a facility with words and creating images that is not found anywhere else, really.
Thank you.
All right. Any other questions from the students? All right. So we're coming up on time. If the students can please just sign off, I'll talk to the judges for a few moments. I'll just give you a preview. So the championship round will be on April 25th in DC. If things go to plan, we'll have tickets for, I'm sorry, April 24th, the Monday in DC. If things go to plan, we have tickets for oral argument in the morning. It was actually attending a Supreme Court oral argument. I think I got it. I'm not guaranteed, but I think I got it. And the afternoon, we'll have the final round at the Georgetown Supreme Court Institute. The bench is looking like Judge Cassis from the DC Circuit, Judge Griffith, who was until recently in the DC Circuit, and Judge McFadden, who's in the District Court of District of Columbia. So a very strong bench for you guys to have your arguments. And I'm just so excited. So we will announce the winners either later today or tomorrow after the next round, but we're so excited. Thank you all so much. Thank you so much.
Thank you to the judges and great job, guys.
Thank you so much.
Thank you.
Let me stop the recording.